To explain a little bit about this history of corporate constitutional rights and how we got to this position that we're in the United States, I'm going to turn it over to my colleague, Jan Rein from Sacramento area, Move to Amend.
Thank you, Kian. Greetings, fellow activists and concerned citizens. Thank you for giving me this opportunity to sound the alarm about a little understood threat that merits everyone's attention and fierce pushback. I want to start with a virtual question. How many of you are frustrated by the spectacle of seeing the reforms and policies you want either watered down, overturned, or never enacted in the first place? Now, I am mentally imagining you raising your hands, and I just want to say that I agree with you completely. I am always frustrated by it. So this all comes down to corporate rule, which both scares me and makes me angry enough to devote a lot of my time and energy to doing legal research and writing to educate the public about the illegitimate doctrines that allow, indeed promote, corporate rule. Move to Amend's educational goal here is to inspire a massive people's movement strong enough to rip these doctrines out of our Constitution by the roots. We need to get rid of it, root and branch. So this talk is about the root causes of harmful corporate rule and the structural change we need to end it so that we can have a democracy truly accountable to us and not to corporate interests. Move to Amend's We the People amendment strikes at the roots by stating that constitutional rights belong only to human beings and that money is not protected speech under the First Amendment. Move to Amend's amendment is the only one. There's a bunch of them proposed running around, but ours is the only one that ends both money as speech and the doctrine of corporate constitutional rights. Most people already know about the Supreme Court's Citizens United decision, which put on steroids the legal fiction that money is protected speech under the First Amendment. I'm not going to talk about that. What I am going to talk about is the harm caused by the invention, literal, out of the air, I could have said something else, but out of the air invention by the Supreme Court of constitutional rights under the 4th, 5th, and 14th Amendment and other parts of the Constitution, including the non-money as speech aspects of the First Amendment. Most people know absolutely nothing about this problem, which has grown so enormous that it threatens everything we hold dear, including continued life on this planet. Now, let me follow up with another virtual rhetorical question. And this is a foundational question. In a democracy, who is the sovereign? Who created government? Well, I again am imagining you mentally thinking to yourself, we the people. And you would be absolutely right in saying that. We created government, we created corporations, and neither one is serving us very well, as Kian has so well pointed out. So the We the People amendment is not just about policy, it's about the principle of self-government. It's about who should decide whether or not a polluting factory is placed in your town. You who live there, or some multinational behemoth corporation whose directors live in luxury far away and who are completely unaffected by what's happening to your town. I always cringe when I hear people say we should have a seat at the table. We own the table. It's us that own the table. We should decide who sits at our table and what they do when they sit at our table. So I'm now moving into the harms caused by the application of the corporate constitutional rights doctrine invented by the Supreme Court. First, a little background. For the first 100 plus years of our nation's history, corporations had no constitutional rights. But starting in the late 1880s, the Supreme Court literally invented so-called corporate constitutional rights. Now, I want you to understand that a corporation is an artificial vehicle to accumulate capital and to do business. When courts give constitutional rights to a corporation, they are giving constitutional rights to property, not people. So this is like the sci-fi movies we all watch. I love sci-fi, where the human beings create the robots, and eventually the robots take over and rule the very human beings who created them. Would you give constitutional rights to your hammer, to your lawnmower, to your computer? I think not. These are tools. These are inanimate tools. And corporations are tools in many ways, and they don't serve us well. Okay, so court-made constitutional rights allow corporations to undemocratically impose pollution, water contamination, environmental destruction, and other assaults on unwilling communities and individuals. And this is all in derogation of local control and democracy itself. I call this the constitutional right to do harm. These harms fall most heavily on the poor and marginalized communities. You don't see any toxic waste incinerators in affluent white suburban neighborhoods. So these harms also disproportionately impact communities of color and our youth who are the most threatened by climate change. Time and time again, corporations have successfully challenged the constitutionality of laws and regulations enacted to protect the public health, safety, and welfare. So let's get into some real case law examples. I'm a member of Move to Amend National's Law and Research Committee, and we've read a lot of these cases and boiled them down in our educational materials to, summaries. So here goes. This is even shorter than the summaries. The first one is a Fifth Amendment case involving the Takings Clause. In 1922, in Pennsylvania Coal Company versus Mahon, the Supreme Court struck down a state statute to prevent the sinking of homes and public structures. The court said the statute violated the coal company's constitutional rights under the Fifth Amendment Takings Clause, which says that there shall be no taking of private property for public use without just compensation. Now, this case set a precedent for future takings cases, which corporations have brought. In a takings case, if the statute or regulation is not struck down or repealed, the government, read you and me, the taxpayer, must pay the corporation all the profits it would have made had the legislation not been enacted. Now, what community or city can afford to pay the corporation all of its profits for God knows how long? Who can take that risk? This would bankrupt most communities, all little communities and many cities, and indeed even the state. So this is not just about the cases that actually reach the courts. It's about the statutes and regulations that are never enacted in the first place because communities and states can't afford to take on these large, huge conglomerate corporations with their fleets of lawyers and unlimited resources. So you can see that this has a chilling effect. And indeed, some communities, under the threat of corporate legal bullying, have enacted and then repealed their ordinance banning, for example, fracking or whatever, banning toxic waste importation or whatever, because they're just going to be slammed in every way possible. The next case is a Commerce Clause case. Now, these cases, actually, it's a series of cases, and these cases don't per se involve a situation in which the corporation is claiming a violation of a specific constitutional right. Instead, these cases illustrate how corporations use other parts of the Constitution to avoid being regulated. So, in City of Philadelphia versus New Jersey and other cases, the Supreme Court, having found that toxic waste is interstate commerce, has used the Commerce Clause to invalidate state and local laws that are enacted to halt or at least limit the importation of toxic waste into their communities for disposal. Children have actually died after running through fields contaminated with toxic waste. And I don't mean they eventually died. They died the next day. Not a pretty sight. So before this case, the inspector showed up at the food processing plant, the slaughterhouse, the construction site, unannounced. The result of this case is that attempts to protect the public from dangers stemming from commercial activities, for example, food contamination, drug impurities, safety hazards, environmental hazards, all of these attempts to protect the public from this are thwarted by removing the advantages of surprise inspection. So now, once the food processing plant, drug manufacturer, or factory gets the warrant, it covers up or temporarily removes the hazardous condition and returns to business as usual once the inspector leaves. The final case I'm going to talk about is a tobacco advertising case. In Lorillard versus Riley, the Supreme Court invalidated a Massachusetts statute that banned advertising for some tobacco products within 1,000 feet of schools and playgrounds. The tobacco company challenged the ban as unconstitutional under the First Amendment free speech clause. So this is one of these non-money is speech cases. This case pitted the children's health and the state's substantial interest in protecting the health, safety, and welfare of its citizens against the tobacco industry's profit motive to maximize profits by addicting children at an early age so that they would become lifelong customers. The Supreme Court did find that the state had a substantial interest in protecting the health of its children. But despite this, the Supreme Court invalidated the ban, invalidated the statute, saying that the statute, the ban, was not sufficiently narrowly tailored. Now, we know two things from studies: that children's tobacco use increases when they are exposed to tobacco advertising, think Joe Camel, and that tobacco use, especially in children, can cause long-term health problems and premature death. Yet the court failed to weigh the relative importance of the competing interests. The result was that the court elevated the court-created requirement that the regulation be narrowly tailored above the children's right to health and long life. The children lost worried parents lost, common sense lost. This is just not good. I could talk about a lot of other cases, but time does not permit. But they're all horrible. Let me just say that. Now, I also want to note that the court has extended free speech protection under the First Amendment to corporations, despite the fact that corporations neither had nor needed free speech protection for nearly 200 years of our nation's history. So now, I suppose you're wondering how we got from a time when we ruled corporations to a time where corporations rule us, the ones that created them. The Constitution does not mention corporations. And for the first 100 plus years of our history, corporations were strictly controlled and had no constitutional rights. Corporations could not even exist unless the state legislature enacted legislation called a corporate charter that created them. So corporations couldn't even be created without an act of the legislature. These charters were revocable and limited the lifetime and powers of these corporations, and they typically restricted corporations to a specific project, for example, building a bridge for the public good. Early corporations also had unlimited liability. There was no hiding behind the corporate veil. By contrast, today's corporations have perpetual life, limited liability, and are virtually unrestricted by these charters, which they can get just by filing an application and paying a small fee. So now corporations can do anything. I mean, these huge umbrella conglomerate corporations can do any number of businesses, like producing food, marketing food, manufacturing drugs, selling insurance, drilling for oil, you name it. These huge umbrella conglomerates can have like hundreds of businesses all under their one corporate umbrella. So this is not good. Big is not good. To top it off, the corporate constitutional rights doctrine has no legal foundation. It is based on false premises. The popular belief is that corporations became people under the 14th Amendment by virtue of the Supreme Court's 1886 decision in Santa Clara County versus Southern Pacific Railroad. This is not true. This, I repeat, is not true. The confusion arose from a court reporter's false, unofficial, post-decision comment that the court had given corporations 14th Amendment constitutional rights. Comments have no legal validity. They are a legal nullity. And the court's decision made no such ruling. In fact, the court explicitly ruled that it was not going to decide the constitutional question because the case could be and was decided on other grounds. So bottom line, corporate constitutional rights were invented by the combined actions of one court reporter and later by Supreme Court decisions resting on this falsehood. The Supreme Court has perpetuated this false precedent without ever giving any rationale or justification for why it should treat artificial constructs as natural persons under the Constitution. Now, I just want to leave you with some take-home points. Whenever a court decides that some statute or regulation violates some corporation's constitutional right, it's a slam dunk. There's no discussion on the merits, whether this is good policy, whether this is bad policy. There's no consideration of the harm that's going to be caused by the corporation's constitutional right to do these things that it wants to do, like polluting towns. There's no consideration of the enormous harm done by allowing the courts to do things under the apron of court-created constitutional rights. So this tells us that no matter what issues you work on, no matter what reforms you work on, all of these are either going to be watered down, overturned, or never enacted in the first place by application of the corporate constitutional rights doctrine. It will all be blocked. People's will should not be overruled by unelected judges with pernicious ideas. So what this shows is that a constitutional amendment, like Move to Amend's We the People Amendment, is the only way that we can rid ourselves of corporate rule. We can't do it simply by passing a statute, because the corporations will just run to the Supreme Court and have it overturned as unconstitutional. So a lot of people, I've heard people say, well, why don't we just pass a statute? It won't work because the Supreme Court will just overturn the statute. The We the People Amendment is the reform that makes all other reforms possible. It really is the only way we can do this. And if corporate power is not controlled by a constitutional amendment, corporations will continue to recklessly do whatever they can to maximize profits, even if it endangers the economy, the nation, democracy itself, and all life on earth. So please tell your family and friends about what you've learned today, and please check out our educational materials on corporate constitutional rights, which there's a website for it. Maybe Kian can show that on the screen. So please check out those educational materials. They give more case examples than I've given today, and share it with your friends and anybody you think who might be interested. So Move to Amend's We the People Amendment is the only one that restores the people's power to where it rightfully belongs. It will take a massive people's movement to accomplish our goal. We need everyone to help in whatever way they can to rid ourselves of this disastrous corporate rule. It's up to us. Thank you very much for your attention.